Hello there, I'm Ian Charles of Wizards, and I'm here with this gentleman here who is a Swindon-based IT solicitor. Perhaps I can get you to introduce yourself.
Okay. My name is Jeremy Holt. I'm a partner in Clark Holt Commercial Solicitors. I specialise in information technology law.
How did you get into that? Must have been a fairly... You've been going for a while now, haven't you?
When I was a trainee, I shared a house with a number of software analysts who worked for people like Logica. The place was awash with copies of Computer Weekly, and they spoke a language of their own. And I really had no alternative but to learn the local language. And I actually found it quite interesting, because law is a fundamentally dull subject. And if you could mix it with a bit of IT, I thought it made it much more exciting.
Right. And I assume, you're clearly still doing it, so...
Without any visible means of support, yes.
somehow getting by. Okay, so 32 years, is it, this business?
Well, we've been in Swindon for 32 years, yes. I was practising for 7 years in London beforehand.
Right. So you're... well, tell me a bit about how IT law works. I mean, who do you work for?
I work for private companies that are buying software or systems. I also work for IT companies that are selling software or systems. A lot of the work is contractual. If journalists were speaking to me, they'd imagine that most of it was to do with hacking. Practically none of it is to do with hacking at all. It's contractual, it's intellectual property related,
Right.
so lots of work to do with copyright. And also one of the things which I concentrate on is employment aspects of computer law.
Right. Now, one of the aspects about or things that's becoming more relevant today in the UK is GDPR. Now, I could see from the information you've set out in front of you that you have a fairly well laid out position on GDPR. General Data Protection Regulation. You tell me about it. You tell me about what it is and how it works.
Okay. Do you want the good news first or the bad news first?
Whichever you deem to be
Okay,
appropriate.
I'll give you the good news first. There's only two small bits of good news. The first thing is that after May next year, which is when the General Data Protection Regulation comes into force,
Right.
General Data Protection Regulation equals GDPR,
Right.
you will no longer have to register under in relation to data protection with the Information Commissioner's Office. So the checks that you used to have to, or the transfers of £35 that people used to have to make, that is all being scrapped because it's felt that it was no benefit to business to be able to do that. So that's the first bit of good news. The second bit of good news is I will endeavour in the rest of this interview to try to explain in simple terms quite what GDPR is about.
Right.
Shall we move on to the bad news?
Help yourself.
Right. The bad news is there are a lot of new rules in relation to data protection.
Right.
Now, the old rules very largely stay. It's a bit like another layer on an onion. So you keep the old rules, all the things that you're used to, you're still going to have to do in future, apart from the annual registration. But there are a lot of new rules that are being brought in. Now, just to define terms, what we're talking about is personal data,
Right.
i.e. information about living individuals. If it's not information about personal data, if it's just sheer financial data, or it's data about machines, or if it's data about geographical locations, that is not covered by GDPR.
Right.
Data protection and GDPR only covers information about living individuals. And those living individuals, for these purposes, are called data subjects. Now, after GDPR comes into force in May 2018, data subjects will have considerably enhanced rights.
Right.
And the people or the organisations to whom they give their personal data will have considerably enhanced responsibilities and
Right.
obligations. Now, there are two different kinds of people who will hold that personal data, and it's important to recognise these words at the start, because otherwise the rest of it will become incomprehensible. The person that you give the personal data to is generally called the data controller, because they control the data and you've voluntarily given them that information. Now the data controller, once they've got that personal data, might subcontract some of the action to an outside subcontractor who will simply process the data, and they will have no long-term interest in the data. Now that subcontractor might be a hosting company that simply holds that data, or it might be a cloud company which is providing some cloud services to the data controller. So we've got two different other people who would hold it, the data controller and the data processor. Sometimes it's quite difficult to tell which is which, but if you think of it in the terms that does the person who's received it have any long-term interest in the data, in the personal data, equals they're probably a data controller.
Right.
If it's just transient and they're just doing it as a job and they have no long-term interest, they're almost certainly a data processor. Now, under the existing law that applies at the moment, there are quite a lot of obligations on data controllers, but very few obligations on data processors. Under the new law, which as I mentioned earlier comes into force in May 2018, there will be enhanced obligations on the data controllers, and there will be massively increased obligations on the data processors. Now, one of the problems is very largely British business has not tumbled to what's going on. I know that because I've had relatively few questions from my clients about it yet. But it's a bit like doing the long jump. You have to have quite a long run up to it. Because after May next year, if under any commercial contract there is the exchange or the transfer of personal data from one of the contracting parties to the other, you will need to have a section of the contract that relates to GDPR.
Right.
And if there isn't a section of the contract, then you'll need to have a separate addendum or a side agreement or a side letter that covers the data protection element of it. Any questions so far?
Well, I mean, I believe that GDPR also establishes data protection as a human right.
Yes, it doesn't use those words. It may have referred to that in the recital. I mean, it's always been a human right. A bit like the Vikings, data protection came down from Scandinavia. The first Data Protection Act was in 1984 in this country because it was felt that the arrival of computers meant that those running the computers had a considerably unfair advantage in relation to individuals. And so it was felt that that imbalance needed to be redressed by some kind of additional legal rights being given to the data subjects in relation to their own personal data.
Have they always been data subjects?
Yes.
Right. So that's the okay. So your view on this with regards to the appreciation by your clients and by business in general is what?
It isn't sufficiently widely known. Just in the last couple of months there's been an increased interest in it, and some publications like the Financial Times have been doing a wonderful job in bringing it to people's attention. The problem is that there's a long lag time. It comes into force on the 25th of May, and there will be people who will wake up on the 25th of May and think, I've never heard of anything about this, what do I need to do?
We know people like that, by the way.
Right, okay. The good news is that the Information Commissioner has more or less, who is the civil servant who's tasked with enforcing all this, the Information Commissioner, who's a wonderful woman called Elizabeth Denham, who writes a very good blog, has said informally, we're not going to throw the book at you over the first 12 months because there's obviously going to be a certain amount of settling down. Now, if this was a rubbish interview about GDPR, I'd start by talking to you about fines and how the fine on an organisation can be either £17 million, 20 million euro, or 4% of its worldwide turnover.
Yep.
However, what I would point out is of the 17,000 complaints, that were made to the Information Commissioner's Office last year, only 16 organisations were fined. What I've been saying to clients...
So less than 0.1%.
That, exactly. What I've been saying to clients, what you need to worry about much more is the mandatory obligation to confess to the Information Commissioner that you've had a data breach, and also a mandatory obligation to reveal to your data subjects that you've had a data security breach. This is an idea that's come in from America. It was applied quite successfully in California as a means of encouraging people to take it seriously. Now, there's a much greater chance of having to own up to the authorities and own up to the people that you deal with, your customers, about a problem to do with data breach than there is about fines.
Okay. So it's only it's only personal data, isn't it? So
only personal data. When I'm lecturing about this to lawyers, I always say you can go into any graveyard and do whatever you like about the information there, because it's not information about living individuals.
Yeah. Okay, well, that's given us a fair view on GDPR, a sort of outline view. Anything you want to add to that?
I would say I would take it in stages. The first thing that will happen is that if you're giving any information about yourself, particularly if you're giving information about yourself online, there will be 2 or 3 paragraphs that you'll have to read or scroll down before you give the information. And that is because if the data controller is going to use consent as a grounds for holding that data, they have to give at least 11 different pieces of factual information to the data subject before they collect that personal data. I mean, it is quite ludicrous. I spent part of today trying to draft, in as short a way as I could, the mandatory wording that you'd need to give them. Now, when data protection first came in, everybody thought that the answer was consent. You need to get consent here, consent there, and consent everywhere. The modern idea is that the authorities are not particularly keen on consent. They would prefer the justification of holding it to be legitimate interest. A legitimate interest is the idea that you have a reasonable business reason for holding that information.
Right.
And it's got to the stage now where if you think, well, I'll be really clever, I can argue legitimate interest and I'll also get a consent out of them. The latest publications that have come out of the Information Commissioner's Office, who has been trying to give business guidance on this, has been that if you're going to argue legitimate interest, it will be inappropriate for you to try to get consent. I was reading through the consent stuff recently, and I thought, goodness me, this is going to be very, very difficult to get consent, because it can't just be consent where there's 2 sheets of A4 and you sign at the end, or there's a tick box that's already ticked and you have to untick it if you don't agree with it. One of the things that the Information Commissioner is coming down on like a ton of bricks is pre-ticked boxes.
Right.
If you could mention it to the mobile phone companies, that would be helpful, as the line seems to have gone a bit blank in trying to get that message across to them.
Big
So
business in the next county.
Well, I live in hope. So, if you see a pre-ticked box, the person who's doing it doesn't know much about data protection.
Right.
Consent has to be informed consent. You can take an analogy out of medical consent. If I just said to you, can I saw your leg off? And you said yes, that's not consent. If I want to saw your leg off, I've got to give you all the downsides of you having the operation to cut your leg off and what might happen to you later, because that's the only way in which you can have informed consent. Now, getting that informed consent is going to be quite difficult. So there's going to be a big push towards people arguing legitimate interest. There are other justifications that the data controller could use, such as it's necessary to be able to carry out a commercial contract with you, or it's necessary for reasons of sort of public safety, public protection.
So who you are, where you live,
Yeah.
how old you are.
Yeah. Now, the thing to remember about personal data is that even includes just your email address. Your email address is personal data because it's information that can be connected to a living individual.
Right.
So it drills right down. In reality, email addresses is pretty low-grade personal data, so I wouldn't wait up at night too much worrying about that as personal data. But if it was personal data, that is much more intrusive. I think one of the worst cases of data protection breaches that I've read about was an HIV clinic in London that said, I think, that they were going to close for a particular period, so they notified all their patients, but unfortunately they put all the names in the to box as opposed to the blind copy box, so everybody knew who else was attending that clinic. So bad things do happen. And in a sense, in my view, GDPR is a kind of wake-up call to business that if they are going to collect personal data, they're going to have to take it more seriously. And one of the consequences of this, a number of different consequences, the first is that there's going to be a lot more legalese for people to sign. and read. The second is that clean personal data that you can use is suddenly going to become very, very much more important and very much more valuable than it was. Thirdly, the question I get asked all the time is, what about all the legacy data? What about all the data I've collected before GDPR came into force? Well, the further piece of good news in relation to that is that you're not expected to backtrack in this. If you already had the data prior to GDPR, you haven't got to apply the post-GDPR rules to that.
Yeah.
The Information Commissioner feels that that effort would be disproportionate. But, fourthly, the difficult thing about GDPR is that, or data protection, is that it's virtually impossible to comply with everything. It's a bit like exams at school and your parents. All that you can do is the best that you can do in the circumstances. Now, if you've got just about everything right, but you've made a minor breach, and somebody complains to the Information Commissioner, then you can always point to all the other efforts that you've made to seek to abide by the GDPR, and then they will take that into account in mitigation.
So it's best efforts then?
Yes, I think so. I mean, it's like everything else in life. I mean, if you've made a reasonable fist at trying to abide by it, you will be given credit for that.
Good stuff. Perhaps we'll just leave you here for the first one. Thanks very much.
Okay.